So once again, welcome. My name is John Favreau of Trust IT and the Smart Change Project, and I will be moderating this webinar today. So today we are going to take a deep dive into a critical issue facing all of us working with AI in healthcare, the regulatory context, which of course has always been important with the medical devices regulation and the GDPR, but which is making headlines again these days with the recent approval of the AI Act. We're going to be hearing from 3 projects today who are all confronting this issue from different perspectives, but at the same time, all related by their use of AI for different forms of health risk prediction. First, we'll hear from my own project, Smart Change. My colleagues Renato Sabadini and Professor Paul Quinn, both of whom are with the Free University of Brussels, are leading the investigation of regulatory issues in the very demanding environment of our Smart Change project, which involves different populations of youth and includes data sets from numerous European countries, as well as an international partner, posing some interesting questions of data protection. So these first talks from Renato and Paul will help to set the stage for a further look at the overall regulatory environment. In that spirit, we will then hear from Lorenzo Cristoforo, who is a lawyer with the Panetta Consulting Group and the Data Tools for Heart project. Lorenzo is an expert on the AI Act and several other critical regulations like the GDPR. And then we'll hear from Achim Meyer, who is a medical computer scientist with CE Plus and the AI for HF project. Achim is an expert in compliance and certification, among much else. And finally, we'll have a panel discussion with the speakers. A quick word about who is online today with us. A significant segment of our audience today is research and academia, that is, our peers who are involved in the same kinds of issues that we will address today. But we also have significant representation from industry and SMEs, as well as a good group of health and legal professionals. So I expect to get a lot of interesting questions. Speaking of which, a couple of words about housekeeping. As I said, there will be a panel session at the end, but you are most welcome to write questions and comments at any time into the Q&A box that you will find at the bottom of your screen. The recording and the slides will be made available to you after the webinar. Without any further ado, let's go to the presentation. So we will start with Renato and Paul, who will present to us the Smart Change project. So Renato, the virtual floor is yours.
Thank you very much, John. I'm now going to attempt to share the screen. Voila. Okay, so first of all, a couple of words about who Paul Quinn and I, Renato Sabadini, are. So we are from the Vrije Universiteit Brussel, and the Faculty of Law and Criminology, Department Meta Juridica, and our research group, the large one, is about law, science, technology, and society. And our specific subgroup is called the Health and Aging Law Lab. So we investigate and we research issues at the intersection between technology vis-a-vis health and aging and legislation. As John mentioned at the beginning, Paul and I, as VUB, are one of the members of the consortium of the Smart Change project. The Smart Change project, Smart Change is it's not an acronym, but it's, let's say, a name that, a short name for a AI-based long-term health risk evaluation driving behavior changing strategies in children and youth. And It's a 4-year project with 14 partners now. VUB ensures compliance with the relevant EU legislation. And the overall goal of the project is to develop a trustworthy AI-based decision support tool that will help health professionals and citizens to reduce long-term risk of non-communicable diseases by accurately assessing the risk of children and youth. We'll see more in a minute. The project, as you see, is part of Horizon HLTH 2022, like the other 2 projects we are doing the webinar with today. As I said, it's a 4-year project and for an overall budget of almost 6 million euro. You can see the names of the partner at the bottom. Well, you can see it's mostly EU-based country, with the exception of Università della Svizzera Italiana, which is, of course, from Switzerland. And we had also a recent addition, on which I will say a few words later, which is the Taipei Medical University, based in Taiwan. So, what is the need for something like smart change? Well, non-communicable diseases are indeed quite a problem, in the sense that in Europe they are behind 90% of the deaths. Risk factors are several, from low fitness to obesity, and these risks begin to start in youth, both due to physiological changes and bad habits. It would seem easy to recognize this kind of risk in youth, but 2 pieces of information here. Only 35% of doctors in the UK are aware of recommendation on physical activities, and only 13% can state them. Moreover, 80% of parents of insufficiently active children think their children are active enough, okay? So in terms of risk prediction tools for children, there's not really any for that, which is why this project is about creating one. And also taking into account that risk prediction tools for adults are not used in this context. So, with a few images, what happens currently is usually you would have a young kid going to the doctor and being visited, and basically, some parameters are measured, usually weight and other things. And so based on this appearance and on these few parameters, there's usually a positive response from the side of the health care professional. However, if we think that with the introduction of a tool like Smart Change, or a risk prediction tool, that a risk prediction tool would identify, after a certain period of recording certain key health data of the youth in question, that tool would identify what is the risk profile, in this sense, in the long term of the subject. And therefore, it would help also the physician to choose the optimal risk-lowering strategies. This is, in a nutshell, how that would work. So the prediction of future health risk improves detection of high-risk individuals. The risk factor is a prioritization. And third, there is a guidance in goal setting and optimized risk-lowering strategies. So I'm not going to go through all the all the text of this image, but in short, thanks to a tool like Smart Change, the physician would be also in condition to provide a more tailored advice on which are the best risk minimizing strategies for the family and the youth to adopt. And this risk minimizing strategies would also be would also take the shape of a smartphone that provides pieces of advice to the youth in the course of the when it would work together with a wearable, okay? And so the youth would then be stimulated to do physical activity or other activities that would improve the risk profile, improve in the sense of lowering it. Voila. So we, as VUB, thought in the context of this webinar to deal with some issues related to GDPR, to data protection in general, because even though we are now, of course, we've seen the adoption by the Parliament, European Parliament, that just finished its mandate in May, of two key pieces of legislation. One is the AI Act, the other one is the European Health Data Space. Nevertheless, these two pieces will also have to interact in some way or the other with the GDPR. So we thought it might have been interesting to see a few aspects of some of the problems that one can encounter. So I mentioned at the beginning that one of our partners is based in Taiwan. This was a recent addition. This partner was not there from the beginning. It was a partner that joined us later, like 8 months, 9 months later in the project, in the lifetime of the project. And of course, in order to train the algorithm of the AI tool, it is necessary to sift through a significant amount of data, and the Taiwanese partner would contribute with data. The first question is, of course, can that data be processed in conformity with GDPR? Well, the general principle, as can be seen from Article 44 of the GDPR, is that there should be in place, ideally, agreement. Sorry, this was the wrong slide. Usually, it happens on the basis of a thing called adequacy decision. Okay, this a decision by the Commission that deems basically the legislation, the data protection legislation of the third country as equivalent to the GDPR, or ensuring an adequate level of protection. As you can see from the second half of this slide, these are the countries for which the Commission has so far approved adequacy decision. And as you can see, Taiwan is not one of them. Taiwan is a particularly complicated case because Taiwan has been seeking this adequacy decision from the Commission for years, but so far nothing has happened yet, probably also due to the special status that this island has in terms of international recognition, for instance, within the UN system and so on. However, Taiwan has introduced and adopted a Personal Data Protection Act in 2015 that somehow, and one can tell that the legislator in Taiwan was somehow following the debate in Europe and therefore tried to produce a piece of legislation that would at least have several points in common, even though there are 2 points, very important difference, especially for projects like ours, that are worth considering. In specific, if you can see bullet point number 1, the Personal Data Protection Act of Taiwan does not refer or define the notion of sensitive data. And second, it does not refer or define to notions of pseudonymous or anonymous data. As Paul will explain later, this is of course quite an important piece of information. However, the Taiwanese legislation, the Taiwanese PDPA, singles out data pertaining in natural persons, medical records, healthcare, genetics, sex life, and so on. And within that legislation, this data shall not be collected, processed, or used unless on any of the following bases. And here there is a list of legal grounds, legal bases that are very similar to those that one can find in Article 9 of GDPR, the article pertaining the legal basis for processing sensitive data. So in this case, for instance, the ground number 4 of the Taiwanese law says that this data, medical records, etc., can be processed where it is necessary for statistics or academic research by a government agency or academic institution, and provided that such data may not lead to the identification of a specific data subject. So in this sense, we can see that also in part there is a take-up of the reference to Article 89 of GDPR, highlighting the principle of data minimization for data processed for research reasons and the similar. This is what I just said. I'm conscious of time. So what does Taiwanese case law say? And this is very interesting because there have been 2 cases discussed by the Taiwanese Constitutional Court exactly in relation of citizens laying a complaint because their data, their health records, as recorded in the National Insurance Health Agency database, had been used for research without that consent. What happened, however, in those 2 cases is that basically the court, the Constitutional Court of Taiwan, recognized the right of the processor to process those data on 2 grounds, because on the one hand, there were what they called pseudonymization measures were adopted to protect the privacy of the person, even though it is, as I said before, unfortunately, there's no precise definition of what anonymous versus pseudonymous is to be understood in the Taiwanese law. And the other ground was that the medical research was deemed by the Constitutional Court of Taiwan a public interest of such import that it would somehow balance the right to privacy of the citizens, also in consideration of the fact that the court deemed the data sufficiently protected by the measures adopted by the processor. So in the end, we found out that this way of collecting data would be mutatis mutandi considered legal also in the EU, also taking into account additional measures that can be found in additional pieces of legislation, like a regulation on production and management of electronic medical records, and by Article 78 and 80 of the National Health Insurance Act. In the end, to cut the story short, it probably will not be the case. It won't be needed for us to import any data in Europe coming from Taiwan, as because of their own safety measures, it will be rather us traveling to Taiwan to consult the data in local. But so this was just a short delineation of a problem that some of you may encounter if in the course of your projects you need to deal with data sets coming from countries that have no adequacy decision or other form of official agreement with the European Commission. I'm ready now to switch to, so I'll interrupt the sharing so that my colleague Paul can start sharing from his computer.
Okay, I should be sharing now, Renato. Please inform me if you can't see or hear me at all.
Yeah.
Everything's okay?
We can see you, yes?
Okay, and you can see my presentation.
Not yet. Yes. Yeah.
Okay, very good. Okay. Thank you very much, Renato. So Renato has run through some of the very specific issues we face in the Smart Change project that were particular to that project, including the potential inclusion of a Taiwanese partner, which is not an everyday occurrence for a project, so it's a bit more particular. I'm going to look at some issues we've come across that are more common in European projects. And in particular, this first one is extremely common. We've addressed it in every single project we've ever been in, and I'm sure anybody else who's involved in the regulation of data protection knows it quite well. That's the issue of anonymization and pseudonymization. Interestingly, unlike the equivalent legislation in Taiwan, we know the GDPR recognizes both of these concepts. It invokes them specifically in the regulation. They are often used, but it's very important to be clear of the conceptual difference. What you notice is that lawyers, legal scholars, etc., have a clear, precise definition, usually rooted in the GDPR, of what the two concepts are. But often technical people, medical people we work with a lot, they have a more blurred, different understanding of the two concepts. They often merge into each other. Often concept of pseudonymity and anonymity are used interchangeably. Though I have to admit, this problem that was more common in the past seems to be disappearing. I would suggest that this is because the GDPR raised awareness of data protection to an extent that even non-legal people are becoming more familiar with the terms anonymization and pseudonymization. But nonetheless, they're still important to consider, especially because legally they obviously have two very different meanings, and these meanings are very important in EU projects because they discern what you can do with particular data sets, who can do it, what you can do, and what are the restrictions upon those data. And also, one thing I would say that we have learned from experience, not only in Smart Change, but every EU project we've ever worked in, is that it's really necessary to realize that an understanding of the legal definition is not sufficient in any real-world case. For example, I, as a legal scholar, can tell you what the GDPR says about anonymization. As I will talk about in a moment, I can also quote the Article 29 working opinion, some scholarly articles, maybe even a bit of case law from the European Court of Justice. But in each and every case, what you need is a contextual analysis of the circumstances in question. So you need to understand what data is being used, who's going to use it, and to discern what is personal data and what is anonymous entails this two-way discussion, this multidisciplinary discussion between legal and non-legal expertise. I think it's almost impossible that a lawyer can look at a complex data set and nowadays and discern whether they're personal data or not. It's necessary to have a lot of interaction with technical partners, and only with this two-way interaction is it really possible to discern in a particular circumstance whether data is personal or not. Okay, so quick recap: GDPR and anonymization, as Renato alluded to. Recital 26 specifically states that the GDPR does not apply to anonymous data. There is the recital. It's quite useful. It's a good anchor point. If we look for it quickly, we don't need to look for it now, I'll just say, but the key words are reasonably likely. This is a key decision point in legislation. Also, you see reference to other factors such as available technology and the availability of other potentially complementary data. And why is this definition so important? Well, in purely legal terms, it's a black and white notion. It represents a trigger factor. If you're dealing with anonymous data, you don't apply the GDPR. If the data is personal and not anonymous, you do apply the GDPR. So it's a big decision point. And it means deciding on whether this big legal burden that is the GDPR applies or not. And as a consequence, anonymization can seem a very attractive prospect. At least in theory, we all know in practice, anonymized data is very hard to achieve for the reasons I will go to quickly in a moment. And so we would submit also to you today that one thing we have learned that you need to be very careful of in the EU project environment is falsely promising before a project, perhaps in a proposal, that you're going to use anonymous data, because often once you look at the data more closely and what you propose to do with it, it won't meet the definition of anonymous, and the project can come into difficulties. So it's very important to be careful. As I said, the practical reality is different. Anonymization is very difficult to achieve in reality, especially of large and complex data. And a lot of this comes down to not the definition per se in the GDPR, but this key opinion, which is quite old now, by the Article 29 Working Party. So it was established before the GDPR, but its guidance is still considered authoritative. It's not law, but it's still considered very authoritative. And it sets a very high bar for the concept of anonymization. It gave reference to a number of factors. I won't go through them all, but obviously you have to take into account computing power, which, as we know, increases at a very high rate all the time. So what was anonymous 10 years ago may not be anonymous now. What is anonymous now may not be in 10 years in the future. The same goes for the availability of complementary data. And another key thing, which is always necessary to explain to non-legal partners, is that you're not allowed to take into account the good motives of a data controller. They cannot silo data, away from other data sets and claim that they will not use reference data to de-anonymize. That's not acceptable according to this opinion. So this opinion sets a very high standard, and the result is, because of also recent technological improvements in computing power, in algorithmic power, in the availability of online data, it's very difficult to claim that any large, complex data that in any way relates to people in any way is anonymous. It's becoming increasingly difficult, and it's the personal nature of data is also becoming increasingly unintuitive. What do I mean by that? It means that you can't look at data and use your human intuition and easily see if it's personal or not. You have to perform more complex forms of analysis now, but because of the availability of online complementary data, because of the availability of other aspects, such as a high level of computing power. There is also, however, recent case law that in some way clarifies certain issues, but not to a great extent. And there is a lot of discussion now in academia about whether the opinion from 2014 has become outdated given technological advances, etc., and that it foresees too maximalist a notion of anonymous data, and whether we need something of a rollback. And some authors are pointing towards the case such as Breyer and saying that we need a more relative notion of personal data, taking into account the data in possession of the person who is controlling a data set, and not just every possible piece of data out there. So that's one key issue, very difficult. Then the issue of pseudonymization. The GDPR recognizes that pseudonymized data is personal data, so we know that means that all the requirements of the GDPR apply. They need to have a legal base, respect data protection principles, and facilitate data subject rights. And discerning the difference between pseudonymization and anonymization, as I said, is difficult in practice. And it requires a careful contextual analysis on a case-by-case basis. So saying what is anonymization, there is no black and white simple answer. Rather, the answer is different in every project, in every circumstance, and it depends on the data in question and what is being done with that data. The same goes for pseudonymity. Determining what is a good level of pseudonymity is not simple. There is no correct answer that applies in all cases. It's, again, highly contextual. You need to look at what is being done with the data, what are the desired outcomes, and to what extent can you do things to the data to reduce the ease of identifiability. Again, as with anonymization, too highly pseudonymized data can also present problems. So it's also necessary to take that into account. Looking at the legal requirements for pseudonymization, Article 25 of the data protection regulation talks about data protection by design, and pseudonymization is invoked in that article as a potential mechanism to improve data protection by design. However, the Article 25 of the GDPR does not make it compulsory, and this is not the same as some legal approaches in various member states. So here again, this is a classic problem at an EU project. The GDPR is only one element. You have to look at member state law. If you have many partners working in many different member states, especially in Germany, where you have disparate laws on data protection, this can be very complex because you need to consult each legal system. And this relates not only to pseudonymization, but many other areas I don't have time to go into. Again, pseudonymization is also encouraged by Article 89 for scientific research. And again, as I said, stricter national provisions may apply. And now just the final few moments. I know we're running out of time, so I'll try to be quick. Our project, as Renato said, involves the use of children's data. So another issue we've had to look at is the issue of consent. We all know that the GDPR famously introduced an option for children to consent to some forms of data processing by themselves. However, this only relates to information society services. The GDPR does not define these services themselves, but points to this other directive. And if we look closer, if we look at point B here, it's services provided, essentially online service, most likely for remuneration. So whilst this is in the modern social media context, this is a broad category of services. It's by no means representative of all types of processing of children's data. And in the concepts of an Horizon project processing children's data, most likely for scientific research, this GDPR initiative for children's consent does not apply. So we have to fall back on the general notion of consent. However, the GDPR is rather silent on what age children can give consent, and it leaves the position to member states to decide for themselves. So again, this is another problem. We see a large amount of variation across Europe. As a rule of thumb, you should assume it's 18, but there are numerous nuances and exceptions. This creates more problems, more administration in a project, because you have to ask parental authority for the processing of data. And there are exceptions. For example, in France, the law is somewhat complicated for information society services. In France, there is a provision, I believe, whereby for simple forms of data processing, children may be allowed to consent, but for more complex forms, it may not. Again, what this means, I'm not an expert in the French provision, but this is quite complex to determine what this matters in each and every context. And I know the UK is no longer in the EU, but they are hopefully going to be involved in Horizon in the project. And here you have, this is the DPO guidance for UK data protection. You say even within the EU, even within the UK, excuse me, there is no set standard, with Scotland having a different understanding of when children can give consent to data protection, data processing than the rest of the UK. However, just my last slide, I will be very quick. That's not the end of the matter when considering this. When you're thinking about the processing of children's data or anybody's data for scientific research, you can't just only look at data protection laws. Many states have specific laws concerning scientific research that may or may not apply depending on the specific context. There can be laws concerning ethical approval of scientific research, laws relating to schools specifically, research in schools, research with children, and there is much variation at a national level, which unfortunately we don't have time to go through today. So that's all from the VUB and our discussion of smart change. Thank you very much.
Thank you very much, Renato and Paul. We do have a question that I think it would be useful to answer now because it is specifically about anonymization. We have a question from Joris, which says, anonymization is also an act of processing. So on what legal basis should data be anonymized by a research institute and made available to a company for AI product development?
Yeah, this is also a very interesting question because there is even variation in member state law about whether anonymization itself is an act of processing. So the answer depends on where in Europe you are. So even with the GDPR, this is not clear-cut across Europe. If you look at the Article 29 Working Party opinion, I agree it would suggest that anonymization is an act of processing. So in that case, the anonymizer needs a legal basis to process. And discerning whether that would apply in a particular circumstance is quite contextual, I would argue.
Great. Thanks very much for this, Paul. And thanks to you, Renato, also. Okay, so once again, thank you very much. What I find really exciting about this webinar is that everybody is looking at a different perspective from a different point of view and drilling down on different things. So in that spirit, now we will pass the floor to Lorenzo, who will tell us about some different aspects of the problem, including the AI Act. The floor is yours, Lorenzo.
Thank you, John. Thank you, everybody, for joining this workshop. I'll be sharing my screen. Can you see well?
Yes, looks great.
Great, thank you. So thanks again. I'm a lawyer in a law firm based in Italy. I'm partner of this law firm, which is called Panetta, and I'm leading the legal effort for data tools for heart. And so leading the work package dedicated to ethical, legal, and social impacts of this project, which builds on pre-existing projects like You Can Share, Big Data Heart, My Health, My Data, Fair for Health, and many more, in order to leverage the progress which has been already developed and ensured during these important different projects. It's quite a complex project, and it tries to deliver a real-world data platform consisting of, I can say, 5 main tools, but maybe there are even more. The first one is a federated learning platform to guarantee privacy-preserving data analysis without the data leaving the hospital, so ensuring data minimization and possibly security. Then we have another tool which is dedicated to data ingestion and extraction to standardize and ensure the interoperability of the data extracted coming from electronic health records and other clinical records from the hospitals. Then we have NLP, natural language processing, multilingual NLP tool to translate and harmonize all the data coming from the hospitals, and it works in 7 languages all across the Europe. The first tool is dedicated to the production, to the generation of very debated so-called synthetic data for further research and AI testing and experimentation. And the last one, is the virtual assistant, meaning a text-based conversational virtual assistant, which must help clinicians and all the users of the platform to navigate through this platform and large scale all the data sets that will be available in the platform. This is a more detailed overview of the tools that will be available for you in this presentation. I would say that all of these tools are mainly aimed to unlock the potential of the reuse of the data, especially for AI development and the AI systems and models application, trying to solve some of the legal and also ethical hurdles which so far has slowed down the definition of a true harmonized research area in the European Union, trying to solve some of the issue which Paul has efficiently highlighted some minutes ago about anonymization and pseudonymization, also in view of the European health data space, and trying to provide the market and the research area with tools which enable privacy enhancing and privacy preserving processing and reuse of the data which have been collected by the hospitals. We are very punctual because the Artificial Intelligence Act, which is a very complex legislation, is expected to be published tomorrow in the official Gazette. So it will become effective in the 1st of August, 20 days after the publication in the official journal of the EU. And then we will see that there is a sort of layered application of the provisions of this important regulation in the next month and years, depending on the level and of risk, and depending on the nature of the AI systems and models at stake from time to time. As I said, in my opinion, this is one of the most challenging and important legislations which have been adopted by the EU in the last years. It's very diagonal. It applies on top, obviously, of all the other legislation and tries to build on the General Data Protection Regulation and many other important laws which have been adopted in the last years. It aims to ensure that all the AI systems respect the fundamental principles of the European Union and safeguard our rights as citizens of the EU, and especially as users of artificial intelligence systems and models, or as targets of artificial intelligence models. And it focuses on human-centric and trustworthy AI. So it has a very, not only legal, but also ethically oriented approach to manage and to launch and use, launch on the markets, put into service and use of the AI systems and models. And it also aims to ensure that AI technologies are not detrimental in any manner to any public interest, meaning environment, health, public policies, and obviously the rights of all people. It has, after the final version of the Artificial Intelligence Act is very different from the first one, which has been proposed by the Commission. It is a hot debate occurred during the negotiation of the various versions of the Artificial Intelligence Act in the last 4 or 5 years. Also, the definition we will see of the Artificial Intelligence Act has profoundly changed, starting from the first version and the last one. It has adopted a very risk-based approach, as in the GDPR. So it has identified mainly 4 degree of risk, which must be associated and evaluated by all the developers and users and deployers of artificial intelligence systems. Some of them are considered as prohibited because the risks are too high for public interest, health, environment, and individual rights. So they simply cannot be put on the market and in use. Other, and it is a very broad class of risk, are considered as high risk. Whenever an AI-driven system is considered as high risk, all the actors through the chain of value from the developer to the final user will be burdened by a number of obligations of certification, of conformity, of transparency, and so on, and to ensure that all the individual rights remain totally safeguarded during the use of the AI systems. And then we have limited purpose, limited risk and minimal risk classes of artificial intelligence systems. And then in the not in the first version, but in the last versions of the Artificial Intelligence Act, also a new not classes, but type of artificial intelligence model have been introduced, which is very important, which is called GPI, which means General Purpose AI models, which is very flexible. I'll go very quickly through some of these slides because I want to focus specific aspects. In December of this year, of 2044 and 24, all the provision regarding prohibited practices will already enter into force, which means that prohibited practices will have to be banned by the end of the year. Then in a year, we will have the application of the provisions about general purpose AI systems and models. And then in a couple of years, starting from August, we will have the application of the high risk system related obligations for some specific so-called harmonized high risk artificial intelligence system. And then going on until the in 3 years, we will have the almost final application of all the obligation of the Artificial Intelligence Act. You can see here the final definition which have been adopted at European level. This is very comprehensive and quite complex. Artificial intelligence systems now means in the Artificial Intelligence Act a machine-based system that is designed to operate with a varying level of autonomy and that may exhibit adaptiveness after deployment. And this is very important, for explicit or implicit objectives, infers. It must be capable to infer from the inputs it received how to generate outputs such as predictions, content, recommendations, decisions, and so on that can influence physical or virtual environments. So the characteristics, the features, the main elements of an AI systems are autonomy, adaptiveness, capability to achieve specific objectives autonomously, the capability to infer and deriving outputs autonomously from the models and the inputs that the system receives from the context and from the external organization which uses the AI system. It should learn from the inputs it received to produce outputs. And then last but not least, it must be able to influence environments, meaning that it must have an impact on the physical or even digital or virtual context in which the AI systems operates. The definition of general purpose AI models is quite different because general purpose AI models is any AI model including where this model is trained with a large amount of data using also self-supervision at scale that displays significant generality. This is very important, and capability of efficiently performing a wide range of distinct tasks, regardless of the way the model is placed on the market, and that can be integrated into a variety of downstream systems and applications, except when it's used for private purposes by individual persons, so privately. As you can easily see and understand, this is a very wide-ranging definition of so-called general-purpose AI models, and it means that they are also, in most of the cases, there will be a component of more complex, sometimes, or artificial intelligence system or of other systems, which also incorporates the GPI into their functioning and operation. A specific type of general purpose AI models are generative models, which are defined in the AI Act as a typical example for in the recitals of the AI Act, and they are considered as an example of a general purpose AI model, given that they allow for a very flexible generation of context like text, audio, images, or videos. The reason why I wanted to focus general purpose AI models is that in Data Tools for Art, most of the tools that we are developing are likely to fall into the definition of general artificial of GPI, as I just mentioned, so general purpose AI systems, and will have to be somehow treated in compliance with all the obligations of the Artificial Intelligence Act whenever if they will be put on the market and in function without the boundaries of a pure research environment. This is why the scope of application of the Artificial Intelligence Act is quite complex. On the left, in green color, you can see the various level of application of the AI Act. So it doesn't matter if the artificial intelligence system are developed or used within or without the boundaries of the territory of the European Union and of the member states, but it will apply whenever the target of the artificial intelligence models and systems will be people within the EU, or whenever outcomes are used towards people within the EU. We have a number of derogations from the application of the AI Act, but you can see in red color 3 which are very relevant, not only in my opinion for the Data Tools for Art, but for most of the research projects funded by the European Union. The first one is that the AI Act does not apply to artificial intelligence systems and models, including their outputs, when they are developed and put into service for the sole purpose of scientific research and development. This is very common. It means that whenever an AI model is tested and developed within a specific and predetermined scenario of research, that the AI Act is very likely not to be applicable. Then the regulation shall not apply also to any research, testing, and development activity regarding artificial intelligence systems and models prior to their being placed on the market or put into service. This is also very relevant because this can also be relevant in a competitive, I would say, scenario, provided that as long as the system are not placed on the market or put into service. Last but not least, the Artificial Intelligence Act doesn't apply to artificial intelligence systems whenever they are released under free and open source licenses, unless they are placed on the market or qualified as prohibited AI systems, obviously, or require enhanced transparency under certain specific requirements of the Artificial Intelligence Act. And this is a more detailed explanation of what the derogation about scientific research and scientific development of artificial intelligence systems and models states. These are the actor. So we have the provider and the deployer. These are the main, I would say, player in the artificial intelligence market, because the provider is any natural or legal person, also public authority, agency, or other body that develops an AI system or a GPI, and which has an AI system incorporated into another systems, provided that these systems are put on the market or put into service, also in a white label mode. While the deployer is any natural legal person or public authority, agency, and so on, which uses an AI systems under its authority, except like in the GDPR for the processing of data, where the AI systems is used in the course of pure personal and non-professional activities. This is a crucial slide because you can see here the threshold of risks which have been identified by the European Union. So as we said, there are unacceptable risks. So any kind of practice based on the AI falling in this class must be simply banned and prohibited. Then we have high risk systems, transparency, enhanced transparency risk for all the systems which are used, especially in the digital environment, to produce specific outcomes and which need to be very clear about the fact that there is an AI system behind the functioning of a specific tool online towards the users of this of the system, like, for example, for deep fake and everything which is produced digitally and synthetically online. And then we have minimal risk, whereby no obligations of the AI Act shall apply. About iris systems, we have two complex annexes which identifies almost all the systems which nowadays, as of today, must be considered as high risk. On one end, we have Annex 1, whereby a number of so-called harmonization legislation are identified, which trigger the application of all the obligation of the Artificial Intelligence Act for high-risk systems. So, for example, the medical device regulation, which will be the subject of the presentation by Hakim after me, it's the application whenever an AI systems is used as a component of a medical device, so as a software as medical device, for example, or is itself a medical device. In this case, the AI system is by law considered as high risk. Then this is a very broad identification of the risk, but that's the indication given by Annex 1 of the Artificial Intelligence Act. Then we have specific areas whereby all AI systems, whenever they are used in a specific sector or for specific purposes, are considered as high risk, like biometrics and the employment sector, or for law enforcement purposes, and so on. I go very quickly. This is a matrix that has been produced by the International Association of Privacy Professionals and Artificial Intelligence, which identifies, I just wanted to give you an overview of the tons of obligation which applies especially to providers of artificial intelligence systems, but also to deployers whenever they are considered as high risk. Very crucially, also to connect to what Renato and Paul said a few minutes ago, data protection will be absolutely crucial, because we have we have big data feeding artificial intelligence. So a number of obligations will apply to mainly to these four classes of data. So training data, input data, validation data, and then testing data. Where all of these data sets will be absolutely crucial and undergo a number of specific requirements under the Artificial Intelligence Act in order to be considered as reliable, as not discriminative, as sufficiently representative to achieve the data accuracy and quality of not only the data and the artificial intelligence system itself, but also for the final outputs produced by the artificial intelligence systems and model. This is why Article 10 of the regulation establishes that the dataset used for training, for validation, and testing of high-risk systems must comply with specific quality criteria. They have to be relevant, sufficiently representative, as I said, free of error, unbiased, and complete. They have to have appropriate statistical properties and reflect also the context, meaning the geographical, for example, behavioral and functional context in which the systems will have to be deployed and used. Here you have some of the obligations which apply to general purpose AI systems, which includes generative AI. More or less, we can say that in brief, all of these obligations relates to transparency and clarity about the fact that the users, all of us, are interacting with an artificial intelligence system or model. So, for example, deepfake, synthetic audio, images, or video, or any kind of AI-driven content or AI-produced content online will have to display a disclaimer, a privacy notice, an artificial intelligence policy, which makes very clear that you are interacting with a and artificial intelligence systems. Then in some cases, which are clearly identified by the Artificial Intelligence Act, whenever a systemic risk, meaning a high risk, for example, for public health, for individual rights, for public policies, for environment, and so on, can be triggered or can be caused by these kind of artificial intelligence systems, other additional obligations can apply. And as Paul said before about the identification of what is anonymous data or not, also in this case, it will be absolutely necessary and crucial a strict cooperation between legal and also ethical expert and technical guys. Last but not least, the Artificial Intelligence Act specifically mentions, for the very first time in European legislation, synthetic data. In a couple of provisions, they are specifically not only included as a new type of data in the Artificial Intelligence Act, but in my humble opinion, they are also equated somehow, paired and compared to more anonymous data than not pseudonymous data. Because if you see Article 10 and Article 59 of the Artificial Intelligence Act, synthetic data are always mentioned together with anonymized or anonymous data, and not with pseudonymous data. It is needless to say that there is a hot debate about the nature of synthetic data. So I'm not saying that they are anonymous, they must be considered as anonymous, and so on. But in the Artificial Intelligence Act, these two crucial provisions put synthetic data together with anonymous data. As I said, and then I am concluding, there is a sort of last tool that we are developing, that we are working on in the Tools for Art, which is a code of conduct under the GDPR. So a piece of elective rules encompassing and including ethical, legal, but also technical standards and rules, which tries to solve some of the and tries to overcome some of the main issues which arise from the current legislation, especially the general data protection legislation, in order to boost the reuse of the data, in order to foster the scientific research in terms of secondary processing of health data. Savasandi, that in this case, the European Health Data Space, which was a draft when we wrote the proposal of Data Tools for Art, will be absolutely crucial. But we deem that a code of conduct in this case will be somewhat something which will remain necessary, especially for the interconnection between the Artificial Intelligence Act and the data protection legislation. So we will strive in order to have a draft that will be a legacy of the project for all stakeholders on the market. And this is a sort of tool that we are trying to develop in Data Tools for Art. Thank you for your attention, and please, at the end of the game, I will be more than happy to respond all of your doubts and questions.
Thanks very much, Lorenzo. In fact, there is a question here, which we'll take during the panel because I think it's relevant to you and to others. So we've now heard about the AI Act, and now let's take a serious look at the effect of the AI Act on the medical device regulation. So I'd like to invite Achim to take the floor and give us his perspective from his project. Thank you.
Thank you, John. Thank you, Lorenzo. Please bear with me for a few more minutes. And as John has introduced, I'm going to try and give you a very brief, short insight into things you should consider when you at least want to secure the chance to further what you've developed as a research project into a full-fledged medical device, meaning gaining market authorization so you could put it into use, regardless of whether you want to charge it for money or give it away for free, put it into general use outside of controlled research projects and studies. This is what certification of medical devices is all about. So just very quickly on myself, my name is Achim Meyer. I work as a regulatory affairs expert, a consultant, helping other companies to gain their CE mark so they can put their devices onto the market. I work for a business division CE Plus, which is taking care of medical devices within a larger organization called Reginald. And please feel free to reach out to me should you have any questions even after this webinar. Very brief introduction about the project we're involved in. You can read all of this later on. Project is called AI for Heart Failure, and it has the very noble goal to support and improve the outcomes of heart failure patients. Rather large consortium, 16 partners, led by Professor Dr. Volker Asselberg. What we're trying to do, heart failure, basically, I'm not a medical doctor, so any medical doctor might forgive me if I get this wrong. Heart failure is basically, it's not a disease. It's more of a syndrome. It presents in a way that the patient suffering of heart failure, their heart is not able to perform as well as it needs to provide enough blood and thus oxygen to the entire body, the organs and the brain. So as such, how heart failure can develop can have a multitude of different reasons. So 3 things that AI for heart failure is trying to achieve here is kind of determine the personal profile of a heart failure patient. So to determine what kind of heart failure he's suffering from, and then determine his personal risk prediction. And from that to eventually derive his personal best options on managing his disease, his personal presentation of heart failure, which can be a number of different things like lifestyle changes, medication, up until operations and heart transplants. But key is it's very diverse and it needs a very specific determination of each and every patient. The great thing about how this project is well set up is, rather than doing this from just a research point of view, or maybe a mere healthcare professional point of view, from the very start, it does involve the input from actual heart failure patients. So they're being interviewed, they're kind of accompanying us along the entire development journey to make sure the outcome of this project actually does, well, first of all, address their very needs, but also address their needs in a way that they would trust the outcome. And that's a major topic, I think, in all of the projects. We've heard this before. We need to build trustable AI which doesn't only work perfectly from a technical point of view, but is also presented in a way that it's actually being implemented and used because people would trust it. If people don't trust AI, or if people don't trust technology in a more general sense, they're not going to use it. We are in the fortunate position that with such a big endeavor, we wouldn't be able to do everything on our own. So we can build on things which have been pre-developed by other EU projects. Big Data for Heart will help us acquire and manage the data. Fair for Health as a platform to then deliver the service into the clinic or the clinical surrounding, and Future AI as a set of criteria you should understand and implement to build trustworthy AI. And I've seen the webpage of AI for heart failures, and all other projects has also been posted in the chat. So if you're interested in this, into more details of this project, please take a look at the website, and also feel free to reach out. So, certification of medical devices. It all hinges around the medical device regulation. That's the law in place in Europe, applicable to all member states, that you have to follow if you want to put medical devices onto the market. Well, this thing has been drafted, written in 2017. So what specifically does it say about the use of AI in medical devices? Simple answer is zip, nada, nothing. So those were different times. AI was not the topic of the day. It was still very much in research. So it doesn't mention anything about the AI. Does that mean there are no specific requirements on AI if you want to fulfill the requirements of MDR? Well, no. Just a very, very quick recap of how CE marking works really for a medical device. So if you want to receive a CE mark for your medical device, what you need to do is, first and foremost, you need to implement a quality management system. What does that mean in very simple terms? You need a set of procedures that allow you to perform crucial tasks of design and development of your medical device in a consistent and repeatable fashion. And then secondly, once you have that, during the design and development of your very product, you need to, well, compile and retain records, kind of records of the procedures you were executing. And those records will need to fulfill the requirements around safety and performance, which are part of Annex 1 of the MDR. So with that, you need to show that your device, with all of this documentation, eventually you need to show that your device is safe and effective. It's not going to cause harm, and it's going to do what it's supposed to do. So how do you do that? Well, usually the acronym is GSPRs, General Safety and Performance Requirements. The very preferred way to do this is to make use of harmonized standards, international standards which have been kind of approved for use to fulfill certain requirements from the entire list of GSPRs. If there aren't any, the EU might draft common specifications, so kind of the EU writes standards in lieu of harmonized standards. On top of that, there is guidance out there that will help you interpret what's written in the harmonized standards and provide even more details on top of what's written in the standards. Guidance provided by the MDCG group or internationally from the IMDRF. Again, for AI specifically, there's very little, almost nothing out there. Again, does that mean there are no specific requirements on AI? Well, the very last resort you have to follow when trying to fulfill the general safety and performance requirements is following the state of the art. So what's considered state of the art? And that's always a topic of debate. What is state of the art? So from my point of view, we've heard the AI Act is going to be published in the EU journal very, very soon. So it will become known to everyone. It's out there in the public. That can be considered as part of the state of the art, at the very least. So there's no good excuse you could make as a manufacturer to say, oh, we didn't know about those principles described in the AI Act, because they're out there. And you also need to become familiar with them, because latest in 3 years as a medical device manufacturer, you will have to fulfill them anyway. So even here and now, you should consider what's described in the AI Act in terms of general principles you should implement as part of the state of the art. So does the AI Act apply to you? That's a several step process, and we heard about this already. Just recapping it very quickly here. First and foremost, the question you need to answer is, do you fall under the definition of AI as provided by the AI Act? And they've adopted the OECD definition of AI. And yes, it's very vague. Just recapping, some level of autonomy is required, actually. So something which is completely under control by somebody may be able to evade this. But when it comes to adaptiveness, well, it may have adaptiveness. It doesn't necessarily have to. So this is not a prerequisite to be adaptive. The inference thing, infer, that's, I think, the most crucial bit of this definition. So that means it doesn't say compute, it says infer. And the current interpretation, this is certainly this is going to cause some debate, which will go on for a while. But the current interpretation of this is that, of course, deep learning systems would fall under this definition. But also, maybe surprisingly, it's more traditional knowledge-based systems are considered to also be captured by this definition, as well as advanced statistical systems like support vector machines, which you might not think of naturally as being AI. According to this definitions, many would argue, yes, they are AI according to this definition. So this is something to watch closely. If you think well, we're doing statistics, it's not AI. Keep an eye on this, how this interpretation develops over the next few months and years. So assuming you are falling under the definition of AI, do you really have to fulfill the AI Act as a high-risk device, as we've heard from Lorenzo? Meaning, do you really have to undergo certification according to AI Act criteria? For medical device manufacturers, those are criteria on top of what's already required by MDR. So basically, do you build software? Yes, then you might fall under this. Or does your system include software which might, if it fails, cause a safety problem? In very layman terms, this is the first thing to consider. If that's the case, do you have to work with a notified body? So do you have to submit your stuff to somebody else, a third party, to review it, to receive CE marking and thus market authorization? That's the current decision graph. So yes, there's still going to remain class 1 devices you can self-certify, where you don't have to work with a notified body for the AI-specific things to receive market authorization. Once you got to that point, you're wondering what you have to do on top of MDR requirements. So I've tried to do a very brief comparison here in between the major requirements put up by the AI Act on the left and MDR requirements in the middle. And as you can see, there's kind of some correspondence in many areas, starting with risk management. And there's a few blank areas in MDR where the MDR doesn't put up specific requirements, but the AI Act does. And please remember, I would consider those requirements, well, you should at least consider them and have a good justification as to why you might not consider them applicable to your kind of product. What I'm going to do in the next few slides is, given the type of audience we have here today, I'm going to try and focus on those things you should take into consideration during the early phases of a product development. And I'm going to start with something which might appear obvious to any medical device manufacturer: risk management. This might be new to other domains, but to medical devices, this is, well, kind of at the heart of everything we do. We start with risk management, trying to hypothesize what could go wrong and how we could safeguard against it as good as we can. The only thing which kind of comes on top of this from the perspective of the AI Act is, well, yes, you need to consider AI-specific risk, technology-specific risk when you're doing risk management. We're still waiting for AI Act-specific international standards. They're being developed. It's going to take a while until we get them. But something you can use already as a good starting point, there is a BSI or something, a technical report really by the BSI and the AAMI. Builds on top of 14971. It does provide a list of AI-specific risks you should consider. First and foremost, you would expect that bias is, of course, on that list, and you will find it there. So what kind of influences could introduce bias, and how can you try and safeguard against it? This is probably going to be on the top of the AI-specific risks. Anyway, so the other thing is human oversight. This is we heard about this before, just in my terms here, really. The AI Act kind of spells out a rather skeptic view on AI. It shouldn't be left unattended. They would very much like a qualified user to be in the loop. This is what it says. It doesn't say should, it says shall. So this thing shall be under supervision. And as a manufacturer, when you're designing a product, what you should do is think about how do you enable users to kind of, to fulfill their responsibility for this kind of human oversight. And one of the major terms which sticks out here is you need to enable them, you need to design the system in a way that they can correctly interpret the output. Interpret doesn't necessarily mean you have to explain the inference, the reasoning of the AI. Explainability is, of course, that's the holy grail of interpretability of your system. It's great if you can explain, well, see, this is how I got to my conclusion. If you can't do this, you need to think of other ways for a human to understand what the output could mean, how reliable it is, whether it should be trusted, or whether they should rather maybe seek second input or not use the output at all. So this is basically something that the human oversight requires you to do. And you should do this, you should think about this during the very design, the early design of your system. And then something we heard about a lot today, and it's just a pleasure to reiterate on this, data management. Because any deep learning system, its behavior is going to depend on the data you feed into it. Any statistical system, like support vector machines for same, which might be a good reason why they should fall under the AI Act. If you feed bogus data into a statistical system to calculate your regression or whatever, I'm not an expert in this area, the output is going to be bogus as well. So what does it require you to do? It does require you to write procedures for things like acquiring data, managing data, labeling data, and QAing data. Very briefly mention that this is one of the baseline requirements of MDR as well, having procedures in place that allow you to perform certain tasks in a consistent and repeatable manner. And as you can see, if you want to get quality data for training and testing purposes, well, that data needs to be acquired, managed, labeled in a consistent way. And you also want to be able to repeat that process if you need to acquire more data. Right, so that's the reason why I need a quality management system, or extend the quality management system with procedures on data management. And also, of course, whilst you're in the process of acquiring data, QAing data, so saying, okay, I like this, I'm going to use this for training, I don't like it for reasons, I put it away. You need to keep records of all of this as part of your technical documentation. And just a fun fact, the data you've acquired and used for training and testing purposes shall be made available by request to the notified body later on, just as another motivational bit to do this properly. Somebody else might want to take a look at it. A quick comparison to what you have to do as a medical device software manufacturer anyway. Part of what you have to implement is, I'm just throwing another standard out here, is IEC 62304, which describes in many, many details how you, or what you need to do when you build software. It describes the entire software lifecycle and stuff you need to do whilst developing software. Part of it is talking about configuration management. Well, there's two major goals for configuration management. One is, again, reproducibility. So if you build software, you put it onto market, and this whole thing runs like a charm for 3 years, and then all of a sudden you get a bug report. What do? You have to be able to go back 3 years and recreate your system and just fix that one bug. If you can't, well, what are you going to do? You don't know what you have. You might have to rerun the entire verification and validation from scratch. So from this point of view, configuration management done right is what you need to do to be able to recreate your system. Another aspect you could add to this, which becomes even more important for AI data, is reviewability. Only if you have proper records of everything, you can review stuff. Primarily at two distinct points in time. Prior to the initial release, you want to review whether your data was suitable, whether you can already determine, well, there might be bias in the data. Review prior release. Review at a later point in time, once you've kind of at least got some hints on, well, there might be a problem with our system. Where does it come from? Where does that problem might come from? Think of what might introduce, well, primarily bias into your system. And then make sure that, try to think ahead, what might introduce bias, and then make sure you keep records of all of those influencing variables as part of your records. Like, where is the data coming from, the kind of institution, which kind of equipment you use to acquire the data, who's done the labeling and using which tools, because you might find that 1 out of 10 labelers did it entirely different as compared to the others. Keep track of all of this. It is a requirement, and you will need it as part of the conformity assessment, and also for the very reason you want to build a quality product. Think of it from a research perspective, think of it as your lab book. Stuff you would take note on, so you could revisit it later on to see whether you've kind of diverted into the wrong direction. And also you want to describe the entire process of gathering data to others, so maybe they could reproduce your research results. Another very important aspect on data sets is something you need to plan for from the very start. For conformity assessment, you basically need 3 distinct sets of data. Well, of course, you need data to train the model in the first place. Then you need data to determine the performance of the model within the lab, bench testing. So this is still done by developers, by data scientists. And then eventually you need data where you can show, where you can prove that the whole thing, once put into its intended environment, like into clinical routine, that it still performs as expected when it meets the real world. For the second type of data, the bench testing, the lab testing, preferably you'd keep a part of the data separate for that. If you don't have enough data and your statistician says, well, it's okay, we can do cross-validation, yeah, you can do this mix and match approach where you subdivide the data into training and then test data several times and then average the results. Speak to your statistician if he would agree that that's a viable approach. The third type of data, the validation data, where you want to show that the whole thing works under real conditions, that has to be kept strictly separate. Machine learners shouldn't even see it. So to avoid any chance that for whatever reason you are overfitting your model, that you are kind of building towards that golden data set, that it would work well with this golden data set, keep that strictly separate. So at the end, you could run that money shot where you say, okay, this is data which has never ever been seen to the system previously, and it still works as intended. Yeah, and as I said, you absolutely need a statistician on board to calculate the numbers, whether you have enough data or not. So what's going to happen in the next few months and years? Lorenzo has mentioned it already. This thing is going to come into force, the AI Act, very soon in a staged approach. For medical devices, the requirement to certify according to AI Act requirements will become active in about 3 years. But you should prepare it as soon as possible. Like I said, even if you're doing just research today, but you want to kind of keep the chance to move that research on into productization, data management, proper data management as described is something you need to do right now, because otherwise it's going to be impossible to retrofit this later on. Stuff you haven't documented now, you won't be able to retrofit later on. As mentioned already, harmonized standards, which would further describe how exactly you're supposed to fulfill the requirements from the AI Act. Well, there's a mandate out. There is still yet to be developed. And yeah, I'm expecting a lot of friction in between those standards for the AI Act, which is a horizontal standard covering many, many domains, where medical devices are just a tiny little bit of them. Many of those standards are gonna have some friction with already established standards, specifically for the MDR and IVDR. And the EU is going to put an expert group in place to try and iron out those potential conflicts and answer a few questions which are not quite clear yet from the AI Act, like what actually is an AI system to start with, and then further on to things where the AI Act might even seem to conflict with the MDR. Just name dropping here, sandboxes for one are going to be really, really interesting in the positive sense from an MDR perspective. And the other is predetermined change control, which is something where any MDR person would say, oh, no way, not going to happen. AI Act says, yeah, it's going to happen. So I'm going to be really curious how that turns out in terms of interplay in between the AI Act and the MDR. Right, started with this one. Again, please feel free to reach out, and I'm really looking forward to any immediate questions you might have, either for me or the other presenters in this webinar. Thank you very much.
And thanks to you, Achim. We've had a wealth of information now from our presenters. So I would like to ask all of you speakers to turn on your videos. And we have received in the meantime several questions that are basically all going in the same direction. It seems they're sort of converging on a common preoccupation among the projects here, or at least most of them, and including some of the last things that you said, Achim. I'll try to summarize them. Lorenzo has already answered a couple of them, which have to do with, well, the AI Act, there's a research exemption. So, maybe we don't have to do it, right? But Achim said, well, yeah, but if you do want to do it, then there's some things you've got to do. And to some extent, this is leading towards a question of the preoccupation of many people in this seminar right now. They all have projects. They're working on tools, and they're not sure whether they should be or not certified medical devices. For example, SmartChange is doing health risk prediction tools. They're not all certified. Should we do this? Maybe we don't want to, because Achim, you did say there's a lot of work involved in this. So what are some of the pros and cons related to this? I might as well go directly to you, Achim, for this. What do you see as the pros and cons of remaining just research, or just doing research in general, as opposed to certification?
I'm trying to boil it down to the smallest common denominator, really. It would be a shame if research were to stay research forever. And like I tried to describe, if you want to at least retain the chance to move research into a product, either yourself or by a different company, there's certain things you need to prepare for, and data management is probably the most important one of those. Many other things you can retrofit. You can do risk management later on. You can think about human oversight later on, and hopefully you will find ways to implement a UI for this whole thing that will fulfill those requirements. So maybe you can do this later on. If you don't keep the data, the very data, you won't be able to use them to retrain the model. It's bloody obvious, but maybe something that not every researcher thinking about. Starting with the consent for research, how can I even possibly keep that data to reuse it to build a certified medical product? It all starts with, you might need specific consent from the patient specifically for that. You need a consent to keep that data in the long term, not for a limited period of time for research. And like I said, is kind of to make sure you are able to review for potential bias. You also need to take note of metadata together with the data, so you can properly review whether your data is sound, or later on, if you were to hit a potential problem, you can go back and see, where's that problem coming from? Do we kind of have an imbalance of our data in terms of do we need to add like data for different age groups, data from different regions around the world, stuff like that. And if you haven't taken note of those characteristics from the very start, well, it's going to be gone.
Any other comments on that from the rest of the panelists?
Yeah, I would just say,
Paul.
I agree with this, and I think we all know that with EU research projects in the past, there's been a problem in producing tangible products that goes to market. I think this is something that the Commission should look at in the future when they design the calls, so that they tailor it in a way that encourages it to be more pragmatic in this regard, because I think the problem still remains in many projects that people are just focused on getting through the project and not enough. They have to, including medical device certification. Yeah.
Yes, thanks. Anything else? Something. Oh, Lorenzo, looks like you were about to say something. No? Okay. Fine. I would. Is there a middle ground? You either have research, which costs you nothing, haha, so to speak, or medical device certification, which is very onerous. We saw that, from the presentations here. Many of these devices are more in the category of wellness, let's say. I mean, is there any path to doing something, having a kind of a wellness certification? Renato and Paul, I know you've had to think about this because Smart Change has something to do with this. Renato?
Well, the issue in the case of Smart Change is that it starts as the putting together of two things that in the real world are not considered normally medical devices, meaning a risk calculator on one hand, and on the other hand, a sort of wellness application in terms of its use within the family, okay, and for teenagers and for youth. The fact is that here, at least in terms of the research necessary, even to produce a Smart Change as a self-standing tool without the need of a healthcare professional in a long-term future, let's say, there's going to be the need of maybe at least probably years of research and validation of the results before that can happen. So the question is, while you have these two separate components that in reality are not medical devices, but when you put them together and the healthcare professional becomes a central figure to interpret the data produced by the tool, and in order to formulate advice and a strategy, a risk minimizing strategy for the family, does this become a medical device? The answer is probably yes. Okay, we are going to have at some point a final, like a Mexican standoff at some point in September, October on this, but the answer is probably yes. I think in general, this is also a problem because both the MDR, the GDPR, and now the Artificial Intelligence Act and the EHDS, these are all relatively recent pieces of legislation. For the GDPR, you have already a consistent case law commenting on it and providing an interpretation for bits and pieces that were left ambiguous, so to speak, in the original formulation of the legislation. The same thing is to be expected will happen also with the other pieces of legislation. So this, of course, puts everyone a little bit in an uncertain position as to what interpretation will eventually establish itself. John, you're frozen from my point of view. I don't know if for the others is the same.
His screen.
Yeah. Also for me.
Yeah, I'm afraid it is frozen. There is another question in the Q&A box. Hi, John.
I'm back.
You're back. Yeah.
Of course.
Go ahead. Yes.
Yes. So I missed the last little bit of what you had to say, of course. Sorry about that. I would like to take the opportunity then to ask all of you a question. Renato, you did indicate what you think could happen in the future as things go on. So, and this has a lot to do with things not being really all that clear yet. Everything is so new. In fact, it starts tomorrow, as Lorenzo said. And so I would like to ask each of you to give me your opinion from what you are seeing on what you think is going to happen in the next few years as things unroll. What do you think that people are going to make mistakes about, and what would you like to see clarified better? So Let me just start at the top. Achim, you've already made a few comments about where you think the future is going. What do you think? How do you think people are going to act? And what do you think needs clarified before they can really do it well?
Yeah, I think I've exposed myself as somebody who mostly welcomes what's described in the AI Act. People might hate me for this because I do think that the majority of what's described in there is actually best practice that you should follow anyway. Let aside that you have to undergo formal certification, which is costly and time consuming. But generally speaking, with the principle described in the AI Act, I'm quite happy from a medical device point of view. The two things, like I pointed out already, which I think are gonna cause a lot of discussion, which I hope they're gonna find a compromise on, are our sandboxes, which should be a way to very briefly, like, go live without being certified under the supervision of your local competent authorities, which, if done correctly, should help especially smaller companies to move into the market without first having to overcome that huge burden and the lengthy procedure of certification first. So that's actually something which I'm looking forward to if done correctly. And the other thing is adaptability. This is something where MDR people still shy away from. So you build something, you kind of freeze the design, validate it, and then put it into the market. Having this thing adapt whilst it's in the market is something which kind of makes classical MDR people freak out. But it's certainly something which is kind of a necessity in a fast-moving world where AI is part of. So I don't even think this shouldn't even be limited to AI only, but anything which should adapt rather quickly in the environment it's deployed into. This is going to be interesting. Might have some popcorn and follow what's going to be discussed.
Very good, thanks. Lorenzo, I saw you nodding as you were speaking, so let's go to you next. How do you see the future unfolding? How are people going to act, and what needs clarification?
I'm very much in agreement with what Achim said, but from my perspective of a lawyer, what the future will bring, in my opinion, is that the authorities that will be appointed in order to ensure that all the obligations of the AI Act will be properly complied with during each phase of an AI systems development and then training and use and so on. It will be absolutely crucial that all of us, and especially the market players, will take a very strict ethical approach. In the AI Act, it is absolutely evident that the distinction between legal and ethics are really blurred. It's really blurred. There are tons of obligations which can be considered as both coming from an ethics perspective and from a legal typical scenario. So transparency, non-discrimination, clarity, not human in the loop, and I would say that 99% of the obligations can be considered as both of regulatory and also ethical nature, and that it will be necessary that this kind of ethical approach will be concretely implemented by developers of AI systems and especially models, to protect children, to protect minorities, and in general to protect all of us, because it's not easy to understand sometimes what are the outputs of an AI systems, what is real and what is fake, what is produced by AI and what is real, what's coming from a real world. So considering that not all the AI high-risk systems, the annexes are not as in law in general, they cannot encompass everything that will come in the future, it will be absolutely needed an ethics approach in order to ensure that everything will be put in place, taking into account the safeguard of individual rights. Otherwise, it would be something which may trigger some problem in the future.
Thanks a lot. In fact, this is a good segue to my colleagues in Smart Change because they're dealing with children. So Renato, what would you add to this regarding the way what keeps you up at night about the future, so to speak, in clearing up all of the implications of what's happening?
What's keeping me up at night is the same that gives me hope, which is the arrival of the singularity. So once the artificial general intelligence takes over, maybe all these problems will be solved. No, but jokes apart, what keeps me up at night in the sense is indeed the clarity. We live in a certain sense in very interesting time because the legislator has finally decided to produce very important pieces of legislation on technology that is already probably central, but is going to become even more central to our lives in the future. But because of this, the process, I suspect it will be quite a bumpy road before we get to any clarity for anyone who researches and then produces.
Well said indeed, yes. So last word I'd like to give to Paul to give your thoughts on how you think what you think the future brings for us.
There's too much to go for everything, obviously, so I'll stick to the data protection I was talking about. Yeah, I hope and I believe in the coming years we will see more court cases at the highest level in Europe that will sensibly narrow the notion of personal data to make it more intuitive and to allow further innovation. So that's what I hope, essentially.
Great, thanks so much, and thanks so much to our participants in this webinar who stayed with us throughout this overly long session, which we still wanted to do because we consider it to be so important. So I would like to encourage the participants in this webinar to stay in contact with us. Let me remind you that the recording of this webinar will be available soon, as well as the presentations will be. So follow these links, which will help you to be in contact with us. Sign up, go to our websites and sign up for our newsletters in order to keep informed about our activities. Smart Change is planning a webinar on its co-design protocols and activities in late September, so don't miss that. So once again, thanks to all of our speakers today and to you in the audience, and we're looking forward to the next time. And goodbye, and have a great rest of the day.
Thanks, everyone.
Thank you. Bye-bye.
Thank you. Bye-bye.
Bye.